So the Trump administration and 25 states have now joined to support the fight against statewide concealed carry bans in a challenge which is in front of the Supreme Court. And here, the state that put in place a concealed carry ban might have just completely blown up their own arguments. So let's break down what just happened. Now, before we jump into the video, if you want to support this channel for free, please consider subscribing to the channel. That, of course, helps it to grow. And then also just drop a positive comment down below because that tells the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, I have an update for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within your state. The Hawaii Wolford versus Lopez case is currently seeking emergency Supreme Court intervention, and it has gained a lot of momentum. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states and their catch-all public property bans are permissible under the Second Amendment. Well, recently we talked about, to the surprise of many, how the DOJ and AG Bondi have stepped up in support of this challenge, and they're currently arguing that the Supreme Court should take review of this case. They filed an amicus brief to the Supreme Court, and they argued that it's finally time for the Supreme Court to review these concealed carry bans, which were passed in direct defiance to Bruen. This effort has now been joined by 25 pro-gun states and a lot of other organizations. And recently, the state of Hawaii had to respond to all of these new briefs that were filed to the Supreme Court. And the state of Hawaii essentially argued that the Supreme Court at this time does not need to get involved, that it should be developed further at the lower court level, that more evidence needs to be gathered and a final merits decision needs to be issued. However, the plaintiffs in this case just caught Hawaii in a trap by pointing out how those statements made by the state of Hawaii to the Supreme Court actually contradict what they said in the Ninth Circuit, which was one of the primary bases for why the Ninth Circuit ruled how they did. Now, if you're not aware, this case is a challenge to Hawaii's new laws on concealed carry, which were passed in direct response to Bruen. This law, like others, tried to add more restrictions to concealed carry and created a default rule where individuals can carry firearms on private property open to the public only if the owner of the property provides express permission to do so. Hawaii, in response to Bruen, passed Act 52, and in that statute, they overhauled the state's concealed carry laws and really made it worse than the ones that existed prior. And keep in mind, Hawaii has already had a really bad track record when it comes to concealed carry, where they had not issued really any permits for many years, only a handful in about 18 years, and in one county, they had never issued any permits. Now, because of this, plaintiffs, along with 2A organizations, sued the state of Hawaii. And on review, the district court issued a TRO, also known as a temporary restraining order, which was then later converted into a preliminary injunction. In that decision, the district court blocked the private property rule as likely a violation of the Second Amendment, and they believed it was inconsistent with what was said in Bruen. This case eventually made its way to the Ninth Circuit, along with the California concealed carry ban issue as well. And on review, the Ninth Circuit upheld the catch-all property ban in the state of Hawaii and reversed the injunction which was issued by the district court. The Ninth Circuit relied on older restrictions on hunting in private property, essentially to support what was going on with this statewide concealed carry ban in the state of Hawaii. Now, after that, the plaintiffs asked for the Ninth Circuit en banc panel to intervene and overrule what the 3-judge panel said in the Ninth Circuit. However, that review was denied. You did have some judges like Judge Van Dyke who joined in dissenting, saying that the Ninth Circuit en banc panel should grant review to this case, and essentially he called out his colleagues for once again violating the Second Amendment. Now, all of that has led this case to now seek once again emergency intervention from the Supreme Court. Now, this case has a hard road to get Supreme Court review, since we all know that the Supreme Court traditionally does not like preliminary injunction cases. This case is still at the preliminary injunction stage. It's not a final merits decision. And categorically, and for the most part, the Supreme Court has denied review to all these carry permit cases at this current stage. However, with the United States now supporting this case, it has a better chance of getting Supreme Court review. In the recent amicus brief filed by the U.S. government, they stated that the near complete ban is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. One of the interesting things about this brief here by the Trump administration was that they pushed the Supreme Court to take this case at the preliminary injunction stage despite the court having a track record of avoiding all these cases. They point out that Hawaii in the Ninth Circuit argued that there was nothing else for the lower court to develop at trial and no further evidence was needed in this case. This is critical for what Hawaii is now arguing in the Supreme Court and really just ended up catching Hawaii in a trap based on the arguments they made in the Ninth Circuit and what they're now arguing in the Supreme Court. Hawaii responded to all of these briefs by kind of arguing the same way that most anti-gun states do. They said that this case is too early for review. The Supreme Court should kick the case for now, let the lower court develop more evidence, develop the record, and at trial issue a final merits decision. And also they argue that there is no circuit split, no controversy that needs to be resolved by the Supreme Court. They also tried to push back against the Trump administration stepping in this case by saying that they were an uninvited guest. In that brief of Hawaii, they argue that the United States uninvited amicus brief does not change the calculus. The United States asserts that the court should grant cert with respect to the first question presented because the Court of Appeals erred in upholding the default rule's constitutionality. They go on to say that the United States says nothing about the second question presented, which speaks volumes. Now that's interesting because on the one hand, they're saying the United States brief should be ignored, but then they say not addressing the second question in the brief is persuasive in their favor and should be considered by the Supreme Court. They also double down on saying that this case is too early for Supreme Court review and it needs to be kicked at this time. However, that contradicted what they already said at the Ninth Circuit, and really that blows up their own argument. This was pointed out recently in the brief filed by Mr. Wolford, and in that brief he states that Hawaii argues that this court should deny review to this petition because the record is undeveloped. That argument is irreconcilable with the concession in the lower court that no such further development was necessary. At oral argument in the Ninth Circuit, Judge Schroeder asked counsel of Hawaii, "Can I ask you a question on the preliminary injunction point? What else is there left to be decided, to be litigated in this case?" And the counsel for Hawaii responded by saying that we think that there isn't anything. We think at the end of the day, these are not Second Amendment violations. Now, counsel's concession on this issue is a judicial admission, which is binding and conclusive. That concession, they state, that there is nothing left to litigate was well taken. They also point out in this recent brief that the state of Hawaii is trying to say that their own state history supports this catch-all public property ban and restricted concealed carry at a higher level. And they say because of the state's history, it should kind of override what happened at the national level. In response to this, they state that Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. Effectively, Hawaii is claiming that its tradition trumps the founding. That assertion is self-evidently frivolous. So here the plaintiffs are pointing out that the state of Hawaii has already conceded at the Ninth Circuit and also for the purposes of this petition that there is nothing further to be developed at the lower court level. There does not need to be a trial or a finding on the merits or further evidence because the state of Hawaii already said that that is not needed. Therefore, they cannot now argue to the Supreme Court that they should kick this case, punt it for further development at the lower court level. That contradicts what they already said to the Ninth Circuit and what the Ninth Circuit used to reach their determination. So with the help of the Trump administration, the state of Hawaii might have got themselves kind of caught in a trap and really just blown up one of their own arguments for that they were making for why the Supreme Court should not review this case. A lot of their brief is focused on kicking the case for further development at the lower court level, but again, they conceded that that was not needed. So we're going to see how that plays out, but that is what's currently going on in this critical concealed carry case, which is pending in front of the Supreme Court seeking emergency intervention. As I get more information, as this develops more, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.